Happening right now, the Missouri Supreme Court is considering whether an abortion rights amendment will go before voters in November. Thanks for being here at noon. I'm Kay Quinn. The justices are hearing arguments in a lawsuit seeking to keep that measure off the ballot. If approved by voters, the constitutional amendment would guarantee the right to an abortion until fetal viability. Here to explain the arguments on both sides is 5 on Your Side's Holden Kerwicki.
Okay, this issue is such a hot topic that it actually crashed the Missouri Supreme Court's website because so many people were trying to log on and watch that hearing. The hearing actually comes less than 24 hours after Secretary of State Jay Ashcroft decertified Amendment 3 and removed it from the ballot and the state website, raising eyebrows from both pro-life and pro-choice attorneys. At the center of the argument are the 380,000 signatures collected by the pro-choice group Missourians for Constitutional Freedom and whether or not they appropriately notified voters what they were actually supporting with Amendment 3 and what laws the proposed legislation is actually repealing. Attorneys with the ACLU have argued that the amendment is clear in protecting the right to abortion up to the point of fetal viability, and that the Coles County Court's decision was an unconstitutional attempt by the legislature to add burdensome requirements to this ballot initiative process. The Missouri Supreme Court has actually expedited this case past the Court of Appeals, and the decision is expected to come down later today in whether or not Amendment 3 will be allowed on the ballot.
So how does Secretary of State Ashcroft's decertification of Amendment 3 play out in the courts? Is there any indication?
That's actually an interesting question, and that's a point of contention for both sides in this. The ACLU has argued that, since Ashcroft actually supported them on Friday in that hearing in Cole County, that he is in contempt of court because he reversed that decision in a brief filed with the Missouri Supreme Court. According to the attorneys that I have spoken with, this issue is really going to come down to the Supreme Court decision. If they say this is a good amendment to be on the ballot, it will be on the ballot.
Wow. And is there any precedent?
Not in the state of Missouri. That's really the interesting thing here, because with ballot measures in the state of Missouri historically, the Supreme Court has really just let the voters decide. Now, in other states, Arkansas being one of them, a similar measure just came up and their Supreme Court voted to kick it off the ballot. So this will be precedent setting.
And this is all coming up against that 5 p.m. deadline when the Secretary of State says all ballots have to be finalized. So this has to be done today.
And as of right now, it is not on the Secretary of State's website. Again, that's really a procedural move because of the Cole County Court case. But it's going to be interesting as we run up against that deadline today.
All right. We know you'll be following it for us.
Absolutely.
Thank you, Holden Kerwicki.